Hey, can you hear me?
Yes, ma'am, we're on.
All right, good.
We got a little problem.
What?
Hey, hi.
He's doing a range.
I can't help you on that, especially the one directly to your right. I can't help you at all.
And here's the other problem.
So,
Rachel's not here.
yeah, that one right there. I can't help you with him. You're on your own.
Is this good?
Come back just a little bit.
Well, here, I'll raise the camera up here.
There you go.
Uh,
Richard's tall, so you got to be able to get him in there. Now come down.
he doesn't like it.
I don't care.
They act like you're not here. I don't hear it. I hear it.
Is that good?
Bring it down a little bit.
I got used to it.
There you go. Right
All
there.
right.
Should be good.
Okay.
Well, I have to excuse the podium up because I'm.
Okay. Wynette,
Hey, Fabio.
everybody ready? Not yet, Judge, they're not ready.
How long do we need?
How long do we need, gentlemen?
We're doing papers, so as soon as you pull my guy, I can do paper. It'll probably be 15 minutes.
15 minutes.
15 minutes? Okay.
Yes, sir.
Court will stand in recess.
Yes, sir.
I don't think here, sir. Yeah.
Your Honor, ready?
Something, maybe we should do. Crazy, no, fine. I'm not a crazy, no.
All right, Mr. Schmidt, are you ready?
It's Israel Torres.
All right, Mr. Torres, sir, if you'll come forward, this is cause numbers FC 24-56 and CR 24-153. State of Texas versus Israel Torres. Mr. Torres, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thanks, sir. You can lower your hand. All right, Mr. Torres, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition? No?
Speak up.
No.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes.
Do you feel like you've had enough time to talk with him about the case so that you understand everything that you've read and signed in your plea agreement?
Yes.
Mr. Schmidt, do you believe Mr. Torres to be competent? And if so, do you believe that he's entering into this plea intentionally, knowingly, and voluntarily, and that he understands the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right, Mr. Torres, you are charged in cause number CR 24-153 with a third-degree felony offense of evading arrest or detention with a vehicle that does carry a range of punishment of not less than 2 years or more than 10 years confinement in prison if you were to be convicted and sentenced. Also, the possibility of a fine which may not exceed $10,000. I see that the plea agreement in that case is that you would plead guilty to that crime. In exchange, the state's recommending to the court that the court not convict you, but defer a finding of guilt and place you on 3 years community supervision with a $1,500 fine, $180 restitution, $290 court costs, and $520 in reimbursement fees. The state would also be asking the court to dismiss after your judicial confession of FC-56, which is a possession of a controlled substance in penalty group 1 less than 1 gram. Is that your understanding as well, Mr. Torres?
Yes, sir.
All right, then, Mr. Torres, I would ask you, how do you plead to evading arrest or detention with a vehicle? Are you pleading guilty to that crime because you are guilty of committing that crime?
That plain guilty because you did it.
Oh, yes.
Okay.
Yes, sir.
And has anybody threatened, forced, or pressured you to plead guilty?
No.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No, no objection.
Stipulation is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Yes, sir. I would note that the FC 2456 was filed in the county court of law. It has not been transferred up. Mr. Torres and I have signed the admission of unadjudicated offenses. Does the court wish me to take that to Judge Winters for signature, or are you able to sign that on his behalf?
Just send it back with the paperwork and we will route it down to Judge Winters for you.
Yes, sir. Nothing further.
All right, then let me see if I have a stipulation. Thank you, sir, because I do not have one. Let's see, back it up just a little bit so I can get a focus on it. There we go. Thank you, sir. All right, based on the stipulation of evidence and the judicial confession, the court finds that the defendant, Israel Torres, that there's enough evidence to convict him of this offense. The court will follow the plea agreement. In this case, the court defers a finding of guilt, places Mr. Torres on 3 years community supervision for the offense of evading arrest or detention with a vehicle, a third-degree felony. Court assesses a $1,500 fine, $180 restitution, and $520 in reimbursement fees. In addition to court costs of $290, court finds that FC 2454 shall be taken into consideration with the defendant's plea in this cause. All right, Mr. Torres, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. After that, you'll talk with the probation officers and they'll give you more information, okay?
Appreciate that. Are you ready, Mr. Moore? Yes.
Mr. Manning, who are you ready on?
Judge, we can start with Mr. Henson.
Joseph Ian Henson, CR 24-139, set for arraignment. Go ahead, Mr. Manning.
Judge, we've negotiated a plea in this case and we're ready to proceed. Mr. Henson understands the charge against him as well as the range of punishment. His name is spelled correctly and he waives arraignment on this case.
All right, Mr. Henson, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thanks, sir. You can lower again. Your name is Joseph Ian Henson, is that correct?
Yes, sir.
And Mr. Henson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
You're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you?
Yes, sir.
Do you understand everything that you've read and signed?
Yes, sir.
All right, Mr. Manning, do you believe Mr. Henson to be competent? And if so, have you explained to him his rights regarding this case and that he's entering into this plea intentionally, knowingly, and voluntarily?
Judge, I do believe he is competent. I have explained to him his rights. And I do believe that he's entering into this plea intentionally, knowingly, and voluntarily.
All right, Mr. Henson, and cause number CR 24-139, I see that you are charged by indictment with a second-degree felony offense of aggravated assault with a deadly weapon that carries a range of punishment of not less than 2 years in prison or more than 20 years in prison and a fine not to exceed $10,000. I see that also the plea agreement that you've reached with the state and their recommendation is that upon your plea of guilty, that your punishment should be assessed by the court at 2 years confinement in prison, a $1,500 fine, restitution in the amount of $4,676.59. In addition, you would have court cost of $290 and reimbursement fees of $20. And it also appears that there is a multitude of unfiled cases that the DA's office is asking the court to allow you to resolve in this plea agreement. I'm not going to read through all of those, but they're outlined in the court's judgment. And you would also receive, as part of your plea agreement, your credit time that you've already been in jail of 103 days. Is that your understanding as well, Mr. Henson?
Yes, sir.
All right. Do you have any questions before we go forward?
No, sir.
All right, Mr. Henson, then how do you plead to aggravated assault with a deadly weapon?
Guilty.
Are you pleading guilty to that crime because you did in fact commit that crime?
Yes, sir.
Has anybody threatened you, forced you, or pressured you to plead guilty?
No, sir.
Or it does accept a defendant's plea of guilt at this time, Mr. Manning? Any objection to the stipulation of evidence?
Judge, while there is no objection to the stipulation of evidence, there is a slight correction I would like to make. There is one filed misdemeanor case of theft of property. That's 2023-00135. I was just noticing that I didn't see a dismissal in there, and that is a case that's been filed downstairs in Judge Winter's court. How would you like for me to proceed? Would you like for me to get a dismissal sent over to your office, or have that sent down to Judge Winter's office?
So does Judge Winters have jurisdiction of the case right now?
Yes, Judge.
So then either you would have to have the state file a motion to dismiss in the county court of law, or you or the state would have to ask for the case to be transferred up for me to then sign an order of dismissal. So probably easier just to ask Judge Winters to dismiss it rather than transferring it and filing a motion to dismiss.
Yes, Judge.
All right. Anything, there being no objection to the stipulation of evidence at states one, that is admitted, and the court does take judicial notice of the defendant's judicial confession. Mr. Hartwell, anything further from the state?
Your Honor, nothing further. Victim impact statement was provided to the victims, was not returned. However, we were able to get the restitution amounts solidified. So state is in compliance.
All right. And so does that mean that the victim is either is or is not supportive or has not responded?
Your Honor, give me just a moment, Your Honor, because some of this did come in today. So I just want to make sure if a victim impact statement was given given today, that we have it and can get it to the court.
I do have the victim impact statement.
Okay.
I've got that. I just want to know if the victim in this case is supportive of the plea agreement.
Yes, Your Honor. Victim is supportive.
All right. Thank you. Thank you. Yes, I do have the victim impact statement here, which I'll review and sign here shortly.
Thank you.
All right. Anything further from the defense, Mr. Manning?
Nothing from defense, Judge.
All right, and the court is going to review the stipulation of evidence. I don't believe I have one of those. Mr. Manning, do you have one with you?
Yes,
Can you
Judge.
just display that to the screen? Oh, I'm sorry, I do. I found it. It's here in the middle.
You know, Judge, I think that's reminded of.
Yeah, I found it here. All right, court, having reviewed the evidence, finds that there is enough evidence to convict the defendant of this offense. The court will follow the plea agreement and the recommendation of the state. Court hereby convicts Joseph Ian Henson of aggravated assault with a deadly weapon, a second-degree felony, makes an affirmative finding that a deadly weapon was used, specifically a firearm. The court assesses his punishment at 2 years confinement in the Texas Department of Criminal Justice Institutional Division, also orders him to pay a $1,500 fine, $290 court costs, $20 in reimbursement fees, orders him also to pay restitution in the amount of $4,676.59. The court does dismiss under section 1245 those offenses outlined in the judgment unfiled by the DA's office, and the court notes that the state's agreement is that cause number 2023-135 filed case theft of property between $750 and $2,500 is also being dismissed this day by the state as part of the plea agreement. Court awards Mr. Henson credit for the time that he's already spent in jail of 103 days. Mr. Henson, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over to be fingerprinted. Once you are released from TDC, Mr. Henson, if you still owe fines, court costs, restitution, reimbursement, then you need to report to the courthouse, to the district clerk's office on the top floor, and talk to them about making payment arrangements, okay?
So,
All right, because a failure to do so may result in a warrant being issued for you at a later date.
okay, thank you, sir.
You're welcome. Good luck. All right. Mr. Manning, who do we have next? Is this Miss Bradley?
Yes, Judge.
All right, this is cause number CR 20-1, State of Texas versus China Bradley. I think we're set on her motion to revoke. Go ahead, Mr. Manning.
Yes, Judge, we reached an agreement in this case when asked that Miss Bradley be set on the next Thursday docket for a plea to 6 months state jail.
All right, that being August 15th.
That'll work, Judge.
All right, court sets Miss Bradley for plea before the court August 15th at 1:30.
It should be excused, Judge.
Yes, she's excused. Who would you like next?
Next, we're ready on Mr. Bostic. Richard Bostic.
Richard Tyler Bostic, cause numbers CR 14 dash, I'm sorry, CR 24 dash 126, CR 24 dash 127, both set for arraignment.
Yes,
Go ahead.
Judge. Mr. Bostic and I had an opportunity last week to go over not only his indictments, but his charges and the evidence in those cases. His name is spelled correctly. He understands both charges as well as the range of punishment and asked to be set on the pretrial docket.
All right, the court finds that Mr. Bostic, having waived the formal requirements of arraignment, enters his plea of not guilty into the record and sets the both cases for pretrial. September 26th. That's going to be the evidentiary docket, but that's my next Thursday, Mr. Manning. So I'm just going to go ahead and set him on both of those.
Thank you, Judge. If we get something figured out before then, I'll let the court know.
Yes, sir.
Judge, next we have Mr. Timothy Richardson. He was a write-in for the docket that was requested last week. We were unable to reach, get all the paperwork filed for an agreement of a plea, but we do have an agreed order regarding bail in both of his felony holds, and I think we have one forthcoming for his misdemeanor possession of marijuana as well.
Okay. Does he have any criminal history or anything the court's going to need to consider as part of the PSRS?
No, Judge.
All right. And what kind of agreement do y'all have on bail?
Judge, the state has agreed to allow him to post a personal bond of $75,000 in each of the felonies. And I'm not sure what the amount would be in the misdemeanor. We don't have that paperwork.
Okay.
The misdemeanor should, sorry, Your Honor, misdemeanor should be in your inbox, Mr. Manning. It'd be a $1,500 personal bond.
And you said that this case is not filed. Is that correct?
That is correct, Judge. And Judge, I do note that I'd have the misdemeanor one as well. I'll forward that to Ms. Ventura and we'll get it signed off here.
Very well. All right. Who's next?
Judge, this is Mr. Richardson. If he may be excused, we're
Yes.
still waiting on confirmation of clarification on the time credit for Mr. Alexander. If I may have about 5 minutes, I think we'd be able to get that finalized and get a new judgment out here.
Hey, and hang on. So you said is this Timothy or is this Christopher?
This is Mr. Timothy Richardson. My understanding is that Christopher Richardson has still not hit our jail.
That's what I wanted to make sure. Yeah, I show that he's in the Beto unit. So okay. So Mr. Richardson is excused.
Thank you, Judge.
Judge, ready?
Always ready. Deputy Martinez, you know that. All right, Mr. Manning.
Judge, if you have Mr. Alexander's paperwork, the only thing that's gonna be different is that the time credit is going to be 216 days instead of 136.
That's a significant difference there.
It is, Judge.
One that Mr. Alexander is glad to see, I'm sure.
Sir.
All right, this is cause number CR 21-275, State of Texas versus Brian Keith Alexander. Mr. Alexander, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, you may lower your hand. All right, Mr. Alexander, your name is Brian Keith Alexander, correct?
Yes, sir.
Mr. Alexander, are you a United States citizen who reads, writes, and speaks English?
I am, Your Honor.
Have you ever been diagnosed with a mental condition?
I was diagnosed with bipolar 1.
Are you on medication or under treatment for that?
I'm on medication. Yes, sir.
Do you feel like you have a rational understanding today of what's going on?
Absolutely.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you?
Yes, sir, I am.
Do you understand everything that you've read and signed today as part of your plea agreement?
I do, Your Honor.
And do you have any questions before we go further?
No, sir. My attorney's answered all the questions.
Excellent. I'm glad to hear that. Mr. Manning, are you in belief that Mr. Alexander is competent today, and if so, that he understands his rights in this agreement and that he's entering into this agreement intentionally, knowingly, and voluntarily?
Judge, I do believe he is competent based on the fact that we've had multiple interactions over the course of my representation where we've been able to review the discovery, inquire about certain aspects of the discovery, as well as possible defenses, and then discussion of weighing those defenses and whether or not he wanted to proceed. He is waiving his rights intentionally, knowingly, and voluntarily, and I believe he is ready to go forward with this case.
Thank you, Mr. Manning. All right, Mr. Alexander, you are charged by indictment with a third-degree felony offense of stalking, which does carry a range of punishment of not less than 2 years or more than 10 years confinement in prison and a fine not to exceed $1,500. I see that the agreement upon your plea of guilt, the state's recommending to the court that the court convict you of this offense, assess your punishment at 3 years confinement in prison with a $1,500 fine, court cost of $290, reimbursement fees of $70, and jail time credit of 216 days. Is that your understanding of the agreement as well?
It is, sir, Your Honor.
All right. All right. Understanding the plea agreement and the range of punishment, then, Mr. Alexander, how do you plead to the third-degree felony offense of stalking?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, Your Honor.
And has anyone threatened you, forced you, or pressured you to plead guilty?
No, Your Honor.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection is offered.
That is admitted, and the court does take judicial notice of the defendant's judicial confession. Is there anything further from the state?
Your Honor, state is in compliance with victim notification. Victim impact statement was sent out and not returned.
Thank you, Mr. Hartwell. Anything further from the defense?
Rest and close, Judge.
All right, court will consider the stipulation of evidence. Let me see if I have one here. I don't believe I have one, Mr. Manning. Could you assist the court? All right, thank you. All right, based on the evidence presented, the court finds that there is sufficient evidence to convict the defendant of this offense. The court does follow the plea agreement and recommendation of the state. The court hereby convicts Brian Keith Alexander of stalking, a third-degree felony, assesses punishment at 3 years confinement in Texas Department of Criminal Justice, orders him to pay a $1,500 fine, $290 in court costs, and $70 in reimbursement fees. The court awards Mr. Alexander total jail time credit of 216 days. Mr. Alexander, once you're released from custody of TDC, if you've not already discharged your fines and court costs and fees, report to the district clerk's office and they can talk to you about setting up an arrangement, okay?
Yes, Your Honor.
All right, go ahead and step over to be fingerprinted. Hereby remanded to the custody of the sheriff so he can carry out terms and conditions of the sentence.
Judge, I believe that concludes my business. May I be excused?
Yes, before you do that though, let's talk about Mr. Christopher Richardson. Let's just talk about that. So Mr. Richardson is in TDC, the Beto unit on a 6-year sentence from Smith County. I show a projected release date of June of 2026. What does the state desire to do on that case?
Your Honor, state is looking to proceed on this case.
So are y'all gonna send over a request for a bench warrant, or what do you want to do?
Yes, Your Honor.
Okay, email Ms. Tabraham and let her know that you're wanting to go forward with your prosecution and request a bench warrant, and then we will get that executed. We will set Mr. Richardson then for status on the bench warrant. Set that. September 26th. At 1:30. All right, thank you, Mr. Manning. Appreciate you. Maybe excuse. Good luck in your trial next
Yeah.
week.
Appreciate it.
Ready, Judge? That's it.
Is that it? That's all?
Yes, sir.
Oh, did Amber Simpson show up at the jail at all?
Not that we know of, Your Honor. Nobody's,
Can you check outside to make sure there's nobody in the lobby?
yes, sir.
Amber Michelle Simpson. Mr. Manning, just for your knowledge and edification, I did talk with Mr. Nicholas on this issue. So he is aware. We talked about it before lunch today.
Excellent. I'll look for a motion from him shortly.
All right. Thanks, sir.
Thank you. Report to the police officer that is the release. And then once you get out in the free world, reach out to the police. You have one phone to the police. Once you get out and make sure that it's sometimes you don't get excited. I don't let you out. So if there's a problem, I know that you have something.
Your Honor.
Yes, sir.
No Amber Simpson has shown up.
All right. Then the court is going to find that Amber Simpson has failed to appear as noticed. Court ensured that her notice of setting went to an address that she had provided to the court on a motion to reduce bail prior to her posting a surety bond. The court's going to find her bond to be insufficient at this time, and the court is going to increase her bond to $50,000 cash or surety. Thank you, Deputy Martinez.
Yes, sir. We're excused.
Yes, are you bringing the paperwork back, or is Rachel?
Miss Rachel.
Okay, all right, sounds good, thanks.
Yes, sir.